is the House Judiciary Committee. It is the 28th of February, 2025. And we have a number of bills that we're going to start to move through here. I think we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. We have a quorum. And so we'll move a little slowish but deliberately here as we take on some of these first bills. House Bill 123 is, did this go to subcommittee or am I, no, this did not. There's a motion for a favorable and a second. There is an amendment. So we're going to roll back to favorable. We're on an amendment. It is from Delegate Bartlett that adds a parole or probation employee from the state recommended by the exclusive representative for parole and probation employees as specified and appointed by the governor. The bill also adds the director, the bill already also adds the director of parole and probation within the Department of Public Safety and Correctional Services. So with that, the vice chair.
So I just wanted to put this bill in, this amendment in because they kind of did an oral amendment when they were here and they mentioned this and the secretary verbally agreed at in the hearing.
All right. There's a motion for the amendment. Is there a second? All right, so on the amendment, any further discussion of the amendment? Seeing none, well, you were. All right, seeing none, all in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. There's 15. Anybody opposed? Nobody opposed. Amendment's adopted. We're on the bill favorable with the, or we're on the bill as amended. I have a motion.
Move as amended.
There's a favorable on the second. All right, is there any further discussion on the bill as amended? Seeing none. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield? Yes. Cardin?
Yes.
Yes. Embry? Yes. Oops. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Arakan? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? It's a departmental. Conaway, yes. Kaufman?
Yes.
Yes. And Williams is not here. We have enough to get there anyway. So, okay. That's one. I'm sorry? Yes, Delegate Arakan.
A lot of bills with amendments. I was just wondering if maybe we could do a consent calendar for the ones that are not amended.
So we've kind of gone through this in the past where when we are actually doing bills for the first time, and I appreciate it, that we're doing bills for the first time, we're kind of doing this. We'll see that more on the Senate bills than we will on the House bills,
Okay.
but I promise, you know, if there are Senate, when we get to that point after crossover and there are Senate bills that we've already got that are passed in the same form, yeah.
Okay,
then
gotcha.
I'll be moving those a little bit faster, but just for the purposes of, you know, this. All right, so there's no amendment for House Bill 189, I don't believe, Holly. Where'd Holly go? It's straight, I believe it's straight favorable. I'll take a motion, though. Motion for a favorable and a second. Thank you very much. Any discussion on House Bill 189?
Mr. Chair.
Yes, sir.
I did have one question. I had in my notes.
Valentine?
Thank you, Mr. Chair.
Yes.
I thought I had in my notes, this kind of brings us into compliance with federal law or a federal statute or assists us in getting in compliance. Is that correct?
I believe that is correct. While holding a CDL or a commercial driver's license, if they attempt to drive while their alcohol concentration is over 0.08, then they cannot have a commercial driver's license, a CDL, for 1 year. So basically, it's somewhat equivalent to what you have on the not CDL side of this, but yeah. So if they're found to have been driving with over a 0.08, then they are then they wouldn't have a CDL. Delegate Conaway.
Thank you, Chairman.
not driving a CDL vehicle and they get the DUI, then they couldn't have their CDL license for a year?
Yes.
Okay,
So if they had a CDL
yes.
and they had a CDL, they were driving their own personal car.
Right.
That's the point of the amendment, is they were found driving over a .08, then they would lose their CDL for a year. So it's really an additional penalty on top of the penalties that they would already get for the DUI. Okay? Delegate Cardin.
Thank you. Is this only upon a conviction, or is this also upon a PBJ? It just says if they're found to have drived or attempted to drive, which could be a charge.
Honestly, I think what's putting us in the federal compliance is that, yes, it could be a charge that they've got that.
So they shall lose their license if they're charged with it, even if they're found not guilty?
Shall disqualify from driving a commercial motor vehicle for a period of a year. Oh, no, I'm sorry. It says if they're convicted in number one. Number two, if the individual, while holding a CDL or a commercial driver's license, drives or attempts to drive any motor vehicle while the alcohol concentration of the person's blood is .08 or greater. I mean, I think that what this is looking at could possibly be the interlock, but I don't think that it necessarily comes out with that kind of measurement.
It's conviction.
Where?
It's earlier law.
Where
It's
does
upon a conviction?
So up here.
But that's only for one.
Yeah, because this is on number 5.
This is number 5, and it's
Right
one
here.
of the 5.
Oh,
So that's for number 1.
It says board.
You want to hold it?
oh, yeah.
You want to hold it and look at it just for one more time?
Maybe till the end of the calendar. And we can
Look, so, I mean, I get the point that they're trying to make. The point they're trying to make is, we don't want you to have a CDL if you've been found over a .08. But to your point, that could be, not to mitigate this, but they did get pulled over for a DUI. They blew. Yeah, okay.
Well, right.
Finish your thought, then I'll go to Delegate Moon.
I guess the question is if they blew when they were pulled over, but it was attempt to drive. So if they
turned on the car, if they Atkinson.
Right.
If they were.
But then.
Yeah.
Would there be a case where the case would be, I mean, if there was evidence that was maybe
Yeah, if it turns out they're not found guilty, what is their remedy for losing their license in the first place, I guess? Let's go to Delegate Moon, and then we can go a little further.
Well, I guess now I'm curious if that other section is about interlocks and people who blow when they're on an interlock.
Let's get.
Does that trigger notification? Where does that actual notice go?
Yeah, and I don't know that it would actually know or be able to tell anybody whether it was an over a .08 or not. I mean, it's worth mentioning the individual drives or attempts to drive a motor vehicle while the alcohol concentration of the person's blood or breath right now in current law is .04 or greater. So.
Also,
if they were driving, I'm sorry, just to be clear, if they were driving a commercial motor vehicle and they had a .04, it already says they can't drive it for a year. So all this is saying is if they're driving their own personal vehicle, it extends it to that, but requires that be over a .08.
Okay. Is this consistent with how other states do it?
I think we should find out. I'm going to hold on to this just for a beat. I think it is, and I think it would put us consistent with federal. Here comes Holly.
It's putting us in compliance with the Federal Motor Carrier Safety Administration regulations. It's under 49 CFR Section 383.51, which requires that CDL drivers are disqualified for certain periods of time for certain offenses. So it was in the administration's testimony, which is included in the file.
I just want to make sure that they do have a remedy if they're found let's say there was a calibration issue at trial, for example, where they found out that the person administering the exam didn't have his qualifications up to snuff. I mean, there's all kinds of things. So if they're found not guilty, or if if something happens at trial, do they have an ability to get their license back?
So there are two parts. All right, so first of all, I'm just going to say, do you want to say something? No. You're good, okay. I mean, I'm going to hold it a week. Let's find out a little more information. Let's just make sure that we're addressing those questions. But the statute as it stands has a whole section talking about convictions for the 21902A and the B and everything else. And then in this bottom part, it's kind of very clearly saying, if you're ever driving with a .04 with a CDL, it's sort of independent of whether you actually got charged for it. If they could figure out that if you went to the state police and blew over a .04, they're taking away your CDL already for a year.
Okay.
So it's sort of an extension of that.
Again, I'm not really worried. I just am more,
look, we'll hold on to it for a beat, and we'll try to get some of those answers, those questions answered, or some of those answers questioned. Ooh, it's time to go home. House Bill 236 has a questionable sponsor. There's an amendment, though, and oh my goodness, an interlineated version, which means, oh dear. This went to family? It did. Madam Subcommittee Chair, can you talk a little bit about the amendments that you put on the bill?
Why don't we have Delegate Valentine?
Oh, fine. I guess we're going to have him talk about it. Delegate Valentine?
Okay,
what violence did they do to the bill?
Thank you, Mr. Chair. Yeah. So what we did in subcommittee, and we worked with the Senate on this as well, this brings us into compliance or into conformity with the Senate version. So what we did on page, let's see, on page 3, you'll notice that we struck, page 2, we struck the intentional visual surveillance, which is at the bottom of the page in its entirety. We struck that. And what we did was we put surveillance into the harassment statute, which is number 5 on page 2. And by doing that, what it allows is, as harassment stands now, it says a person may not follow another in or a public place or maliciously engage in a course of conduct that alarms or seriously annoys another. And then there's a criterion underneath that. So for that to happen, it has to have the intent to harass, alarm, or annoy after receiving reasonable warning or request to stop and without a legal purpose. So by adding conducting visual surveillance in an area of another's residence in that statute, all 3 of those criteria now apply. So for someone to either be charged or be able to petition for that order, all of that would, so when my constituent came in and testified, she testified that this was annoying and harassing to her. 2, she tried to get her neighbor to stop. She tried to have law enforcement get them to stop. He wouldn't, and without a legal purpose. So the legal purpose part of this is, and her testimony would have shown, okay, he put a camera in a certain location, okay, and it was brought up in some of our colleagues, well, maybe it was a legal purpose. Maybe he was trying to monitor a certain scenario or certain animals, and she puts something as a barrier. He continues to avoid that barrier. So in my opinion, I would think that would not be a legal purpose because he was doing something to specifically harass her. So under this statute, she would then be able to file for a peace order. And
Go jumping.
yes. Yes. And then the second part of the bill is what was asked for by the second.
It was.
It's a go jumping callback, everybody.
So we just thought it would be a cleaner version by putting it in the harassment statute as one of the other ways that you can be harassed. And then the second part, again, puts in the part where the judiciary requested that then gives them the authority, if they find that this actually meets the criteria, they can have the individual remove or reposition a camera in that circumstance. So that's wording that they asked for already.
Let's do this. There's a motion for the amendment. Is there a second? Thank you. Now, we'll take discussion on the amendment. Delegate Embry.
Thank you, and I think this makes total sense. I just want to clarify, this means she could also seek criminal charges under harassment.
to the harassment statute.
And could you say, I'm sorry, one more time where it fits in the harassment statute? I just pulled it up.
So under, let's see, so in harassment, under the definition where it starts, a person may not follow. Okay, a person may not follow another in or about a public place, comma. We added conduct visual surveillance in an area of another residence where the other has a reasonable expectation of privacy, comma, or maliciously engage in a course of conduct that alarms or seriously annoys. So we added the visual surveillance in the middle of that where it would be one of those three things.
Got it.
Two are already existing.
Understood. Thank you so much.
Lauren, did you get it mostly right? All right, there we go. That's nice. We're on the amendment. Delegate Phillips on the amendment.
I just want to know who came up with that. I think that was really brilliant.
Actually, I have to defer to our Senate colleagues, and I'll say why. When this first came about from my senator, when they brought...
Have you learned nothing?
We actually give them credit. We give them nothing. Give them nothing.
Take the credit. Take the credit.
Myself and my team came up with
But I gotta, we talked about the other day, we're talking about drones and that kind of thing. This actually would apply to that as well, would it? Would it not?
It might.
I'm going to defer. Would it?
I think it might.
It may.
It may.
I don't know.
Particularly if somebody's doing it.
I would think repeatedly if you could identify, but you would have to identify who was the flyer of the drone.
You would have to show a course of conduct. You'd have to show it over and over and over again.
Right.
Privacy.
And I think your challenge would also be, were they flying the drone over and not taking pictures of you? I guess there'd be that question too, because the whole issue here is it's focusing on a person, a door.
Yeah.
I mean, you could have the drone just taking off from somebody's house and flying over somewhere else, I guess, too. But this could be loads of fun.
Okay.
We
look
actually
forward to seeing this.
We actually ended where we started because at the very beginning, she was referred to saying this should be some form of harassment. So we kind of ended up exactly where she started.
Well, and I would say to the fact that it is in the harassment statute where it's not just it happened once and so now we're all going to war. You need to show something more than that. You have to show a course of conduct that is truly, that is harassing behavior. Makes me feel a little bit more comfortable. Anybody else on the amendment? Great. All in favor of the amendment, please raise your hands. Anybody opposed? Nobody's opposed. We're on the amendment and it's a favorable as amended. Anybody have any further comments about it? Want to take any more credit? Just saying. All right, seeing none, the vice chair?
Yes.
Yes. Valentine?
Yes.
Are you sure? Crutchfield?
Yes.
And thank you to the subcommittee chair for helping to guide this process along the way because she did have a big role in this. So there. Delegate Cardin? Yes. Yes. Tomlinson? Yes. Embry? Yes. Tolles? Yes. Schmidt? Yes and add. Yes and an add. Yes, indeed. I'm keeping track. Simmons? Yes and an add. Here they come. I'll come back around. Everybody take a breath. Boucher? Yes. Yes. Phillips? Yes and an add. Yes and an add. Congolo? Yes. Yes. Arakan? Yes and an add. Yes and an add. Taylor? She's not here. Simpson? Yes and an Arakan. Yes and an Arakan. Grammer? Yes and a me too. Sample Hughes? Yes and add. Moon? Yes. Yes. Conaway? Yes and add. Kaufman? Yes and add. Yes and add. Williams?
Yes and add.
Yes and add. For the purposes of adding, the vice chair, you're already on it, Valentine. Crutchfield?
Yes, I would.
Crutchfield adds. Cardin? Sure. Adds. Tomlinson? Yes. Yes. Embry? No, all right, that's fine. The bill is adopted, and Lauren,
Loves you, but not that.
the marks are down the side. Okay? All right, that's nice. House Bill 315. It's a task force. I know, right? Task force. No amendments. Oops, there are amendments. Oh, it went to civil. What do the amendments do, please?
I'm going to let Holly tell the amendment.
Okay.
Oops, sorry, I shouldn't have pressed it. That's okay. So there are two amendments. The first amendment is an MSBA amendment that specifies that the two members of MSBA shall include a fiduciary litigator and a resident of a jurisdiction with a population of less than 250,000. And the second amendment is a Register of Wills amendment, which alters the membership to include two registers of wills designated by the president. And then the rest of the amendments are just clarifying and conform it to the Senate bill, which has already passed out of the Senate.
Motion on the amendments.
Move the amendment.
Motion for amendment in a second. Discussion on the amendments. Okay, all in favor of the amendments, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Anybody opposed? One. You're for it? Anybody opposed? Let's try that again. Nobody's opposed. The amendments are adopted.
Move the bill as amended.
All right, there's a motion for a favorable on the bill as amended. Anybody, is there a second? There's a second somewhere. All right, there it is. Any further questions or comments on this bill? Seeing none, the vice chair?
Yes.
Valentine?
Yes.
Yes. Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? I'm sorry? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes, and an add. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes.
I do not take it personally that nobody wanted to be opposed to it.
Frank did. It's just Conaway.
Right.
Would you like to reconsider? Are you sure? Okay, all right. House Bill, there's amendments. House Bill 437. All right, where did this go? Who is this? Why are we here? It's Claire. It went to family?
Yes.
All right, Madam Subcommittee Chair, Delegate Crutchfield.
Yeah.
It went to criminal. Do you want to talk about the amendments? Who wants to talk about the amendments? Delegate Crutchfield's talking about the amendments.
Okay. Yeah, so the amendment, what it really does is it really ensures that a person has an expectation of privacy just where they are. So what it does is the amendment states, and it's specifically in C, number 2, and where we take out the piece where it says whether an individual is in a public or private place, and instead we put in the location of the individual, meaning that, again, you just don't have an expectation of privacy just in public or in a residency, but you have it actually where you are as an individual, where you are. That should be a reasonable expectation of privacy, that no one will have prurient intent, and that you have that ability to make sure that that does not happen to you.
Motion for the amendment in a second, so we're on the amendment. Is there further discussion on the amendment? Seeing none, all in favor of the amendment? What?
Nothing.
Oh, sorry. All in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. Okay, that's everybody. The amendment's adopted unanimously. On the bill as amended,
Second.
there's a motion and a second. Delegate Conaway, did you want to say something?
Question. So the privacy in a public place, does that mean that, like, this is a public place, but if I spy record, let's say my seatmate here, and he doesn't know it, does that come under this? Or?
You have to have the prurient intent.
Prurient
The
intent.
prurient intent.
Oh, my genitals. So if you're recording his genitals.
Well, why can't they say that? I mean, they're adults.
Prurient, the definition according, stop. Prurient, the definition according to the Oxford Language Dictionary, is an adjective having or encouraging an excessive interest in sexual matters.
So that would mean if you were in a public place and you were using some way to observe cleavage or look under skirts or
I
something
think
like that.
looking under skirts is probably the best example of what we're talking about.
Thank you. Okay.
Yeah. Upskirting is the example you're going for here. Someday when we're all finished with this place, there's going to be a, and like a long video of all the things that we've had to say while we sit in this room. It's going to be great. Pass. Okay. There's a motion and a second on the favorable as amended. Is there any further discussion about upskirting? Seeing none. The vice chair.
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes, and an add. Boucher? Yes. Phillips? Yes, and he thinks he'll add. Congolo? Yes. Erican? Yes, and an add. Taylor? Yes. Simpson? Yes, and an Erican. Grammer? Yes, and an add. Sample Hughes? Yes, and an add. Moon? Yes. Conaway? Yes, and an add. Kaufman?
Yes, and add.
Yes, and add. Williams?
Yes.
Yes. Bartlett, Valentine, Crutchfield, Cardin, Tomlinson, Embry, Pasteur, any of you want to add? Schmidt? I don't see anybody else. Okay. And Taylor? All right. Yep, it's the lines on the side, yeah. Yep. Questionable bill sponsor, but House Bill 442 is here. I don't see amendments. There's a motion for a favorable and a second. Delegate Simpson, do you want to talk about what the bill does briefly?
Adds a forensic interviewer to the list, so that the child still ends up having to testify, but it does add another individual that kind of lessens that.
So these are mostly in they're mostly in child abuse cases?
Yes, mostly in child abuse cases or a child abuse case.
All right. There's a motion for a favorable and a second. Any questions? Any statements? Seeing none. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur is not here. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Semple Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
All right. Ooh-doo-doo. All right. Never-ending saga of Delegate Hill's bills related to the interference of the public safety answering point. Do we have, I'm just saying, we've moved this bill several times. It appears the Senate is now doing the same, and they moved it in the same position. Claire, they moved it in the same position as we have it, so there's no amendments? Okay. Okay. It's a motion for a favorable and a second. Is there any discussion on this bill?
Point is, it is a 911 center or something like that?
It's a 911 center, I think, is the adequate definition for that. I'm looking at Claire, but I think that's right? It's a 911 center, yes. Okay. Swatting broadly, yes. All right. Any further questions? Seeing none, the vice chair.
Yes.
Yes, Valentine?
Yes.
Yes, Crutchfield? Yes, Cardin? Yes, Tomlinson? Yes, Embry? Yes, Tolles? Yes, Tolles. Yes, Schmidt? Yes, Simmons? Yes, Boucher? Yes, Phillips? Yes, Congolo? Yes, Arakan? Yes, Taylor? Yes, Simpson? Yes, Grammer? Yes, Sample Hughes? Yes, Moon? Yes, Conaway? Yes, Kaufman? Yes, Williams? Okay. House Bill 468.
Can we put this to the end? This is the one that Aaron Hopwood has to come.
Oh, right, we have to wait for HGO. We have to wait for Aaron Hopwood. So we're gonna wait on that one. So we're not doing 468 just yet. HGO is primary on it, so we have to wait for Aaron. And that leads us to Delegate Embry's bill. It is her birthday, coming up. So there's a motion for.
When's your birthday, Randy? It's Sunday?
Sunday.
This would be a good birthday
present, she said.
She's laying it on, everybody. All right.
Move favorable.
There's a motion for a favorable and a second. Delegate Embry, you want to tell the committee what this bill does, please?
Thank you. And this is a bill we voted out in this form last session. It extends the statute of limitations for local consumer protection offices. Baltimore City, Howard County, Montgomery County are the current ones. There may be more in the future. It gives them 3 years instead of 1 year, which is consistent with state tort law. And unanimously last year in committee. I think on the floor. And the floor, I believe.
It's not crossfire.
It is, I don't believe it is cross.
No, and don't get me started.
I believe it is.
Touched a nerve there.
Let's move it quick then.
Chamber of Commerce was opposed.
Yes.
They're never going to not be opposed. I don't think so.
It's sort of a natural opposition because, it exposes their members.
I got it. Are there further, there's a motion and a second. There are questions, and here comes Delegate Congolo.
And I just wanted to share my
We're here.
oh, I'm sorry. I thought we were on 468, never mind.
Never mind. 591. Never mind was called. Now I'm back on House Bill 591 with a favorable and a second. Is there any further questions or comment? Are there any further? I got nothing. All right. The vice chair.
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. She is not present. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Congolo? Yeah, is that a yes? That's a yes, okay. Yes. Arakan? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Aaron's here, so we could do that bill now.
Oh, okay. Aaron's here. Where's Aaron? Aaron's right here. You can sit right up here.
They're just making up things.
Okay. You can sit down.
Okay.
You can sit down. You want to ask her a question? What? Okay. Aaron Hopwood's here, everybody.
Hi.
All right, so this is counsel for HGO. We are the secondary on this. They have already passed it. And if someone were to ask me what it passed favorable with amendment 23-0. So there's that. The amendments that was offered in HGO it's a one-line amendment that names the bill. So that's what the incredibly specific amendment does.
The amendment names the bill after the fallen officers from Prince George's County that were killed executing a emergency petition.
I see.
So that's the reason for
Can you give us, well, all right, first of all, do we have to adopt the amendment? I guess we have to adopt the amendment. All right, motion for amendment, is there a second? Fine. All right, any questions about the 468? Yes, 468, we went back, I'm coming. Do you have a question about the amendment or on the bill? Because the amendment's adding a name. Okay, so let's deal with the amendment and get it out of the way, and then we'll go to the next step. All in favor of the amendment, please raise your hands. Anybody opposed? Okay, fine. So now we're on the bill. Is there a motion on the bill as amended? Favorable and a second. Fine. Now, Delegate Congolo.
Thank you, Mr. Chair. So I just want to make sure that I'm clear on the bill. So this bill, the goal is to allow officers to use force in the event that the situation escalates where their harm is at risk, or that's what I understand it to be, correct?
the officer can use force in accordance with the use of force statute. So it specifically refers to the use of force statute in the public safety article.
Right, okay, so, and I appreciate that part of the bill. I did explain this to Delegate Alston. My concern is as a clinician who has worked in crisis intervention with police officers, that oftentimes when people are acutely psychotic, seeing an officer having those experiences can escalate them emotionally, you know, just having the presence of an officer. And I understand that Prince George's County, and, you know, my condolences to those officers who were, who had lost their lives. But what I had explained is that there are other jurisdictions, other states that have used officers in soft uniform paired with a clinician, where the clinician goes in, if it's, you know, a mental health crisis, where the clinician will go in and use their crisis intervention skills, which are far more advanced than the police officer's skills, in order to de-escalate and help manage or bring some stability to the situation, so it doesn't require force or, you know, the police to have to intervene in a forceful manner. So I appreciate the police officers being safe, but I'm also looking at the community members, and when they're psychiatrically unstable, how they react, and I don't want to bring harm to the community is my concern.
Yes, I want to make a statement regarding this bill, because at first I had similar concerns to Delegate Congolo, and when Mr. Marsh sent the voting list out, I was going to vote against this legislation because Disability Rights Maryland is adamantly opposed to this legislation. But I will be a yes today because I took the time to call Delegate Alston, and she made numerous amendments to address their concerns. She sought them out, and the use of force language in there, she tells me, is based on conversations with the Disability Rights Maryland, and she even offered to do some sort of study for them this year and didn't hear back. And I don't particularly like emergency petitions, but I do believe they are necessary at some point. And given the lengths that Delegate Alston met with to try and accommodate Disability Rights Maryland, and the fact that this bill passed unanimously last year with love in my heart to Disability Rights Maryland, I will be a yes.
Yes, thank you, Mr. Chair. And thank you, Delegate Congolo, for your comments. I wholeheartedly agree with a lot of what you said about having, individuals with our law enforcement in situations where we think that there's some type of, say, mental health crisis or something along those lines. I know in your county, you guys have a program along those lines. I know in the city and where I live at, based on an unfortunate incident that happened about 2 years ago, we have started doing that in the city of Greenbelt as well. So that is something I'm very sensitive to, and we have seen it work in a lot of jurisdictions, like you said, not just here in Maryland, but across the country. But I also am supportive of this bill because I know Delegate Alston did take a lot of steps. I remember last year when this bill was jointly assigned to Judiciary, I was one of the members that went to HGO to hear the bill hearing. And there's been a lot of work done on this bill that makes me feel a lot more comfortable with this. I think it strikes a good balance. And so for those reasons, I'm going to be supporting the bill.
Delegate Sam.
Thank you, Mr. Chair. And Lisa, good to see you. I did want to, can you just make that statement again about the use of force, how that all comes together? Because I'm familiar with the use of force with the, the police, and I'm just trying to understand exactly what you were referring to.
One of the reasons for the bill was because at least in Prince George's County, the
Sheriffs weren't clear whether they could use force because it was silent in terms of it being a civil petition. So they were seeking clarity on if they could use force, and if so, what kind. So the decision last year was to put in statute under the emergency petition statute that an officer could use force in line with the Maryland Police Use of Force statute, which is in the public safety article. So it directly references that article, which has to do with de-escalation and meeting the force or using reasonable and proportionate force, I believe.
Okay. No, some departments, so I guess the part I'm kind of a little confused about is that we might have ours in the statute, but each department has a different definition of use of force.
So what this bill does is it refers to the emergency petition statute. So when an officer is serving, going to the individual to get them petitioned, they know that this is the kind of force that they are able to use.
Okay, so they regardless of.
So it's across jurisdiction.
Okay, regardless of their personal, local use of force policies, our state is the part, that part that we have in statute is what they have to immediately go to.
Particularly for emergency petitions.
And the local is not up for question. Okay, thank you so much.
Delegate Valentine.
Thank you, Mr. Chair. And I just wanted to add another perspective of someone who has served these orders and the fluidity and just the changing dynamics of these situations where it's not a court order. It's not something that you can plan to serve. It's you're on a scene, you're in a situation where someone might be actively trying to cut themselves or do themselves harm, and you have nothing, you can't wait 15 or 30 minutes in a remote part of this state waiting to take action. And officers that I've worked with, either for or with or have been involved with, they're always that gray area. The individual's not under arrest. The goal is not to, it is to use force that's proportional just to get them safely in a situation where you can get them to a hospital, to a medical facility. And this will greatly allow these officers that ability and that more comfort that they're not going to be like liable for something. The goal is never to use force, especially in these situations, because we understand that. I know that for a fact. So I will be voting for this bill.
Delegate Tolles.
Thank you. I want to, Mr. Chair, I want to echo and say me too to what Delegate Williams indicated, but also I think it's important to note that you don't want individuals to be, families being re-traumatized and having to come back and forth to court. So we want to be able to ensure that, these emergency petitions won't have them coming back and forth. And just also reiterate that all of the amendments have been accepted by the bill sponsor. And so she did work very hard on this. So just wanted to add that. Thank you, Mr. Chair.
Delegate Taylor.
Thank you. Just for clarity, because I'm not even familiar with an emergency evaluation, like what that means. So what I'm thinking in my mind, and you guys please correct me if I'm wrong, I'm thinking about the situation where there was that incident where the lady was she was clearly mentally, she was having some intellectual issues, but she called the police. They came to her home and they shot her because she had a pot of water, hot water in her hand. Could a police officer use this as a defense, use of force defense, if this statute if this statute's in place? And it could be just outright no, I could be off base, but I just need somebody to help me with it.
Vice Chair.
Thank you, Delegate Taylor, for bringing that up. I saw that video. It was a horrible situation. I think that, I'm looking at the statute, the use of force statute, and I think that, unfortunately, the argument becomes, you look at the actions, the totality of circumstances, the actions of the officers, and in that circumstance, I could see how a jury would say that that use of force was excessive. But we would always keep referring back to the use of force statute to make that determination. Because there was even one officer, because the use of force also says you have to render aid if, that other officer is using force and then they get too excessive. You have to render aid. And remember, in that video, there was the other officer who said, let's go check on her. I'm paraphrasing.
Yeah.
And the other one said, nah, it's nothing. So unfortunately, that situation, I think, is going to, the use of force statute in Maryland, if that happened in Maryland, if that had happened in Maryland, I think all of this would play in. I also wanted to just say something that didn't respond to you, Delegate Taylor, but just as a whole. So yeah, Anne Arundel County, we are quite fortunate to have a remarkable crisis intervention team and internationally awarded. And I'm not saying that just to brag, I'm just saying they really are good. And they have stated that they are training, they're doing a lot of cross-training on other jurisdictions. They did mention Prince George's County. So I understand the concern because it is, in an emergency situation, unfortunately, things can escalate really, really quickly. And there is a judgment call that we have provided to our law enforcement officers to be able to make that judgment call. I can appreciate what Delegate Congolo is saying with respect to having someone like a crisis intervention team to be there to kind of de-escalate as much as possible. But there is a level of de-escalation training that we have already put in place in Maryland. There is this use of force statute that we've already put in place in Maryland, and the rendering first aid requirement is in there. So I feel comfortable voting yes on this, but I also feel comfortable trying to, each of our counties that are represented, if you want to try to emphasize more on that training, that de-escalation, and working with the crisis intervention.
Thank you.
Sorry for the second bite at the apple, but I guess what has triggered in my mind is the young man, Anton Black, who died from the Eastern Shore, and the police did kill him. So does our statute talk about excessive use of force? And not to cross that barrier when we are saying use of force is acceptable?
That was the whole that was what we did during police reform, and that was one of the situations that we were looking at during that time. So
right, I remember that. I was actually on that. But what I wanted to just say is kind of like a gray area. I mean, it's.
Vice Chair.
I'm sorry.
Sure.
I just wanted, because quite frankly, this is one of the reasons why I came here, was because of this, to make this law happen, this use of force. And that was way back with Rodney
King.
Thank you. I wanted to say Taylor, but Rodney King. No, not Rodney King. Was that the LA situation? Yeah, Rodney King. So that's how long ago this use of force issue has been a problem in my mind. And I argued then to anybody who would listen, I kept saying we need to change the law. That's why these convictions that's why we can't get convictions, because we don't have a law that supports convicting a law officer who does more than they should, a law enforcement officer who does more than they should. I think that when looking at this statute and speaking of the totality of the circumstances, so we get to look at everything that the officer did before the situation got escalated and to escalate the situation and after the situation was escalated, because that's where the first aid part goes in. And because we're doing the before, the during, and the after, in our particular statute in the state of Maryland, I think our use of force statute is strong enough that if anybody does, and we have body-worn cameras, so if anybody does act outside of this use of force, then, and it's not necessary and proportional to prevent imminent threat of physical injury, then I think they would be convicted. Would it still happen? It's not going to say it would never happen, unfortunately, because we can't do that. But what it would do is it would, those who actually go beyond the use of force statute, they could be convicted, and it would deter other bad actors from going beyond our use of force statute.
Okay, that sounds good. And I know I worked on that as well. I wasn't obviously on this committee. But I'm on both sides, I guess. I'm supportive of the police because I know how that can be, the challenges that are there. And then I'm also just, I guess, quickly just thinking about that, yes, we do the training. We have to continue to do the training, but it can quickly escalate to excessive and not render that aid right away, as was done with the young man that I just referenced. So thank you, but I'm still reading the information, and I just wanted to make sure I was clearly on the side of understanding exactly what this bill does. So thank you, Mr. Chair.
So, so several of the groups that are opposed that I respect. And so I'm hearing that something has changed in the bill, but you said it was only the title.
You can press the button.
So, yeah, so
The
what is
amendments are referring to last year's bill. So this is identical to House Bill 1019 from last session. That bill was unanimous in HGO, was also jointly assigned here and unanimous here. A lot of work was done last year, and that's what the references are to the amendments. The bill as introduced only referred to the officers being able to use force, and so that wasn't clear. So that was the reference to the use of force statute. That was making that more clear. Some of the things about it would have the extensions of the petition had to be based on the presenting behavior. The original petitioner had to be the person who did the extension. That was one of the things that was added, and just kind of more of the drilling down as to how it would work, because another part of this bill is the 5-day extensions. So there was a lot of work with the advocacy groups who are still opposed. They're opposed because they don't want police officers involved in the emergency petition process at all. So I know that HGO did the best they could to work with them, but they're always going to be opposed on the basis of feeling like in a mental health situation, police officers should not be involved.
Delegate Erican?
Thank you. Maybe council can just bring this back for me. So I just want to make sure that the situation that Delegate Taylor referenced, because this was a woman calling, that was not actually an emergency evaluations call. So that actually wouldn't fall under this bill at all. So then the regular police training standards for excessive and for use of force would be triggered in that scenario. This would just affect specifically the civil process only. Okay, all right. So, and you might not have the vote. Like, I just do not remember this bill from last year. Do you remember it? Okay. Did I have a million questions or no? I mean, yeah. I'm gonna like go back and look and see. I don't know. Did I? Okay, I mean, that checks out. Just Control-Alt-Delete in there. Okay. I'm here, I'm gonna vote for the bill. I just wanted to make sure that I understood that that situation could not be impacted by this bill specifically because it's just about the civil procedure. Okay, awesome, thanks.
So I just, in listening to all the conversation and, you know, I've after listening to all of it, I think I'm actually kind of concerned about our officers at this point. I mean, I would just hate that this would, no, I think that now we got to look at, you know, not just the person who's in crisis, but also the officer who's now maybe going to be in more risk or more situations, or there may be now where there's more liability on them. I mean, there's a lot of paperwork that goes into when you respond and use excessive force. Like I said, I've worked alongside police officers. So, you know, I know what it looks like when, you know, the situation isn't, you know, we don't de-escalate it in the way that we intend to when we walk in. And I just hope moving forward that we offer more support to our officers. And I worry about this now reinforcing some narratives that are out there when there is an incident. And we can't afford for our officers to deal with any more of those false narratives and things that come along with a situation that has outcomes that we weren't anticipating. So I'm just looking at both sides now, and I hope that this doesn't create liability issues for officers and harm to the community.
I think the officers were one of the groups that actually asked for this bill.
Yeah.
As I recall, Delegate Williams can talk more to that because she went to HU.
Yes, thank you, Mr. Chair. Yeah, I was just going to say that I know the sheriff for Prince George's County testified at the bill hearing in support of this bill, and I believe last year had the support of all of the sheriffs from across the state with regards to this legislation. So this was asked for by it started from our sheriff's department, and they were the ones who put in the request for this legislation. In light of what happened in Prince George's County, but then also in conversations with others, realized the need for this on a statewide basis.
Can you share what happened in Prince George's?
I don't remember the full story.
It was.
Oh, go ahead.
You can actually, you can look it up too, because I looked up the names of the people that the bill is named after, and it happened in 2002. So it was many years ago, but they were serving an emergency petition and entered the household and were killed by the individual they were serving the petition on. Yes.
The sheriffs.
So that's who the bill is named after, the two sheriffs who were responding. I didn't hear what you said.
She said, how would this have helped?
Okay. So we've had considerable discussion. The bill is favorable with amendment. We had the motion 20 minutes ago. Any further questions or comments? All right, seeing none, we are secondary on the bill. The Vice Chair?
Yes.
Yes. Valentine?
Yes, I'd like an add.
Yes, and an add? We add co-sponsors?
You may, yes.
Okay.
And the HDO went on as opposed.
Yeah, okay, so we'll add Crutchfield?
Yes.
Yes. Carden?
Sure, and I'll add.
Yes, and an add-on? I'm making a note on that.
Oh, thank you.
Yeah, I got you. I've been here before. Tomlinson is not here at the moment. Embry? Yes. Pasteur? Yes. Tolles? Yes, and an add. Schmidt? Yes, and an add. Simmons? Yes, and an add. Boucher? Yes. Phillips? Yes, and an add. Congolo?
Yes, and a strong advocacy that we're going to better support our officers and people who have mental health concerns and issues.
Yes. Erican? Yes, and an add. Taylor? Yes. Simpson? A weak yes. Grammer? A lot stronger yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes, and an add. Kaufman?
Kaufman, no add though, please.
Yeah,
Yes.
Kaufman is a yes, but not adding. Williams?
Yes and an add.
Yes and an add. All right, thank you very much. I want to make a copy of, I made a note on it. All
I
right,
have the answers for 189 if you want to do that.
all right, I'll come back to it here in a second. Let me keep plowing on and then. House Bill 604. All I'm going to say is that you all were saying this would be a consent docket, and it's been about an hour and 20 minutes, so all right. Yeah, all right. There's an amendment, fairly significant amendment, it seems. We sent this to, where did this go? Who am I? Why am I here? Did we go to subcommittee with this? Yes. Is this you?
Yes.
Oh, you want to tell us what this does? No?
I like that. It's the bill.
It establishes law.
Yeah, establishes law. I'm trying to remember. This is a bill that came over from the Attorney General's office. It is something that they were requesting in response to what they were seeing with regards to what we call vulnerable adults, and basically their caretakers and loved ones taking advantage of them, quite honestly. And so this bill modifies the penalties with regards to theft from a vulnerable adult by a caregiver, family member, or household member. The penalties pretty much mirror what's in the theft statute. I think what's also, I guess, a little bit more unique about this bill, besides the penalties, there's also a restitution portion that is in the bill. We did make an amendment in subcommittee to modify that the sentences have to be concurrent with one another. So that was the amendment that came out of the subcommittee, as well as it would prevent this person from being rehired as a caregiver for a period of time if they were convicted under this statute, as well as the Attorney General can seek penalties under the unfair abuse and deceptive trade practices as part of the commercial law article. And that's my recollection of the bill. I don't clear if I'm missing anything.
Can I have a motion on the amendment?
Move the amendment.
And a second. Okay, great. So now we're on the amendment. So just to be clear, so it says that the sentence is concurrent, which means if they're charged with a theft and they're charged with this, they're not getting any more. This isn't an enhanced penalty above what they're already getting. They're getting the same thing, whether it was a theft or with this. So basically, it's kind of letting the world know, if you were a prosecutor, perhaps, who had one of these cases, I can't think of anyone, maybe right now, that, I mean, this would not apply to anybody that I have right now, but I'm just saying a prosecutor who could have one of these cases would want a conviction here more to put on the record that they were a caregiver and less about adding a penalty.
Right.
And under federal law, they'd be disqualified.
Right.
And then under federal law, that's where they lose, that's where they get the real penalty, is under
Yeah.
federal law.
Under
Yeah.
federal law, they would be disqualified from, or another company would jeopardize their Medicare and Medicaid, I think, funding if they were to hire someone who has been convicted under this statute. And that's really where the real penalty comes in, because if someone is engaging in this level of behavior, we do not want them to just simply lose their job at one facility and then go work at another facility and do the exact same thing.
All right, Delegate Kaufman on the amendment.
Just very briefly, I think that this is also necessary because I remember the Attorney General, he testified personally on this situation and about how that somebody stole a dementia patient's credit card and went on a shopping spree. But unfortunately, because this law wasn't in place, Jane Doe was able a couple months later to get a job at another nursing home, and he was trying to prevent that from being able to happen because it was another nursing home in the state.
Delegate Taylor.
I understand the intent. If a home health care company has to do a background check on all their caregivers. How would the company know the ramifications of hiring this person within the time frame for which it's banned, or, you know, the home care company would be penalized if they hired this person? So is it 5 years? And if it is 5 years, how would the home care company know that, oh yeah, for this particular offense, we have 5 years
Yeah, that's what she just said.
before we can hire them again?
Come up with a background check.
Yeah, Delegate Taylor, that's a great question. I think, like you mentioned, they would do the background check on the individual. You would see the date in which that individual was sentenced charged and sentenced under the statutes. You would have that information.
We would know the offense, but not necessarily know that there is a law for this particular offense that we have to wait 5 years before we can hire them again. I mean, there are all these, you know, how are we putting it on the companies to have to know?
But does the bill, I don't think the bill talks to that. I think those are those are other regulations outside of the scope of this bill. All this bill is saying is, if you're a caregiver and you steal from a client, then you're subject to this. As far as its impact on other areas of the law, I don't think that this touches other areas of the law.
Yeah, I think the 5 years in the federal law.
I think it's a federal, yeah.
So that's not anything new, is what you're saying? This is not
Yeah.
a new?
No.
Oh, okay. When you mentioned it under the amendment, I thought that was being added.
Oh, no, this is,
It doesn't translate liability at all. I mean, it
No.
goes to that specific person. That
I
would be
get
a
that.
very different bill.
I get that.
Yeah, that would
Yeah.
be a very different bill. And I think the regulations on the federal level, and you could correct me if I'm wrong, I think this is a Medicare or Medicaid.
yes, Medicare,
It's
Medicaid.
their regulations that say you cannot hire somebody. And so that's way beyond the scope of this committee.
Okay.
And, yeah.
I was just going on.
Yeah.
Thank you.
All right. Are there further questions about the amendment? No, it's amended. It's,
I just say one thing about the amendment.
yes. No. Claire's got, yeah, okay.
So I just wanted to say one thing about the amendment so that nobody is confused, because the amendment's lengthy. It basically strikes the substance of the bill because it was kind of a drafting error, and relocates the operative prohibition language within the existing crime of exploitation of a vulnerable or senior adult. And this is the way that the Attorney General's office originally wanted it to be drafted. And then the amendments also require it to be concurrent, as the chair previously said.
It makes more sense, in my mind, it makes more sense to put it in the exploitation of a vulnerable adult than where they had it before, or where the drafter, with no offense to the drafter who may be watching, or not. You know, it makes more sense to have it in this section of law, I believe. So we're on the amendment. Seeing no further discussion on the amendment, all in favor of the amendment, raise your hands. Anybody opposed? Don't see anybody opposed. We're on the bill as amended. There's a motion for a favorable and second. Anybody with anything else you want to say about this bill? Don't see anything. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Carden? Yes. Yes, you can add, and I'm making marks. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes, and an ad Boucher? Yes. Phillips? Yes, and an ad Congolo? Yes. Erican? It's not in the room. Taylor? Yes. Simpson? Yes. Grammer? Yes. Erican's a yes. Grammer is a yes. Sample Hughes? Yes. Moon? Yes, and an ad. Conaway? Yes, and an ad. Kaufman? Yes, and an ad. Williams?
Yes, and an ad.
Yes, and an ad. All right. Okay. You're holding 675. Not because we don't like the sponsor, but I think we were holding 675 for a beat. Okay, we're doing that. There are amendments coming for 675, so we're going to skip that one. Delegate Long wants to have a bill in this committee. Jay Long, this one. So here he is. This is a Holly bill. There is an amendment. You handled this in civil?
Yes.
You want to talk about it?
Sure.
Great.
So the bill authorizes a petitioner, when filing a petition for guardianship, to ask for a stay of all proceedings going on until the guardianship is in place, so that they can make sure that foreclosures aren't taking place or other matters where money is being taken out because the guardian wasn't able to serve in their purpose as a guardian of the petitioner. The amendment simply changes. We had this bill last year. We passed it at the end of the session. It didn't get out of the Senate. And we worked with the realtors, which I got confirmation from the realtors, by the way, Holly, this afternoon. They're okay with the bill, with the amendment. And we got a confirmation from the bankers and the Enton people that they're okay with it as amended. The amendment simply changes a petitioner to a party to the guardianship, because there are times when the petitioner is not the one who's petitioning because they can't, because it has to be a guardian or a attorney that does it for them, and therefore it's just clarification.
Questions? The Vice Chair is not doing that. Delegate Grammer.
Thank you, Mr. Chair. Can you explain to me how this works with the foreclosure process? Because the foreclosure process is a pretty lengthy, I mean, it's at least several months until usually the foreclosure process even gets to start. And it's usually an additional several months under normal circumstances before it culminates.
Holly will correct me if I'm wrong, but this allows for a stay of proceedings for a specific period of time. I think it was 90 days, for 90 days only, and then they can proceed. It gives the guardianship the ability for 3 months to try and set up the guardianship so that a guardian can handle all those matters. And that's what it does. So it will, in fact, lengthen it for these specific periods when you have a person in the middle of all this who literally can't do what they need to, and they need to have somebody doing it for them.
And explain to me the petition for guardianship process. So that's a requirement.
Right, that's what this is all about. So you have to petition the court. There has to be a hearing to determine whether the guardian is the appropriate person. I've never done this. This is sort of the elder care bar that handles this most of the time, but it's not always. But they are dealing usually with people who are unable to speak, unable to move. They maybe have some dementia issues, those kinds of things. That's usually, or it could be a child, a minor. That could be also another reason for guardianship.
Okay, all right, thank you.
Other questions on the amendment? Other questions on the amendment? Seeing none. All in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Anybody opposed? Nobody's opposed. It's unanimous on the amendment. All right, so on the bill as amended, there's a motion for a favorable. Is there a second? There is. Any further discussion on the favorable with amendment or favorable with amendment motion? Seeing none. The Vice Chair.
Yes.
Yes, Valentine.
Yes.
Yes, Crutchfield.
Yes.
Yes, Cardin. Yes, Tomlinson. Yes, Embry. Yes, Pasteur. Yes, Tolles. Yes, Schmidt. Yes, and an add. Simmons. Yes. Boucher. Yes. Phillips. Yes, okay. Congolo. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Sample Hughes. Yes. Moon. Yes. Conaway. Yes. Kaufman.
Yes, and an add.
Yes, and an add. Williams.
Yes.
Yes. Motion's adopted. Sorry, you want an ad? Conaway is an ad. 3 ads. Schmidt, Conaway, Kaufman. Okay. Yes, committee is Delegate Simpson again. All right, House Bill 929, we're almost done. This motion for favorable, there are no amendments on this bill where there was apparently peace in the valley. There's a motion and a second for a favorable. Are there any questions or discussion on the bill?
Can council just remind us what it does very briefly?
Let's everybody consent to a protective order.
Okay. Sorry, guys, my brain is just...
No, you're fine. It's fine. It was the defense counsel, the defense bar, and family law advocates who were, if everybody wants to consent to the protective order, they can. The permanent protective order, yes. Critical difference, the permanent protective order. Permanent. Don't see anybody else with light on. Any other questions or anything? Seeing none. Is she here? I don't know what to do. Here I am. The vice chair. Yeah. Yes, Valentine? Yes. Crutchfield? Yes. Cardin? Yes. Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? 929. Boucher? Yes, okay. Phillips? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? Right, so now. Holly can add you on 756. That's fine.
Just curious, if both parties agree to terminate a permanent protective order, can it be terminated?
I would assume so. Maybe we'll find out.
Next year.
Maybe we'll find out next year when they come back for another bill. House Bill 943. I know, right? We've passed this before.
Move favorable.
It's a motion for a favorable. Is there a second? And a second. We've passed this before. And I think it includes the, it was fairly specific. We had like a 5-second conversation about whether we needed to define firefighter while we were sitting over here. And I feel like if you're fighting a fire, you are a firefighter, with no disrespect to actual professional firefighters. But I think the point of this is if somebody is committing arson and there is someone who is injured, a person fighting the fire is getting injured, then they would be covered by this. Delegate Tolles.
Thank you, Mr. Chair. And really, it's because if somebody intentionally commit a fire, have an arson, then only people who pretty much the judges consider to be criminalized for arson is the people that live in the house. But it's also important to protect the people who, if someone was unfortunately die, where someone set the house on fire, committed arson, they should be protected as well. The firefighter. So, that's simple.
There's a motion for favorable and a second. Any further questions or anything on this bill? Don't see anything.
Okay, we're ready.
Okay.
That's another bill.
6 months start today, okay?
Okay, everybody. The vice chair.
Yes.
Yes. Valentine? Yes. Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. You sure? Yes. Schmidt? Schmidt? Yes, and you can't add, there's no amendment. Simmons? We have been in hearings until nearly 9 o'clock every night this week.
That's why we're so punchy.
I know. There are two, okay, Simmons is a yes. Boucher, yes. Phillips, yes. Congolo? All right. Do they have like a permanent carnival up there on Ritchie Highway, by the way? Because it feels like a permanent carnival on Ritchie Highway. Just saying. Drive by it every time. It's like food trucks and carnivals. Congolo voted yes.
Hunter's moving us along.
Oh, Hunter. Erican, yes. Taylor, yes. Simpson, yes. Grammer, yes. Sample Hughes, Moon, Conaway, Kaufman, Williams. All right. Okay, last one, 1116. Well, we have an answer on one of the other bills, but there's a motion for a favorable, it's clean, and a second on the favorable. It's your district mate's bill.
Yes, please, yes, move favorable.
Okay, so an extra favorable. Any questions about the bill? Seeing none. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yeah.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Hang on, just don't run out the door yet. Phillips? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right, I need to do the withdrawns. There's a motion for an unfavorable. There are two bills being withdrawn, one from Delegate Phillips, one from Delegate Weigel. And yes. Yes.
Okay.
On the withdrawal of whichever one was yours.
1158.
1158, thank you.
House bill, and I should do that because I don't want anybody to come back. Well, anyway, House Bill 1158 was a follow-on to the gun accountability bill, which passed last year. It is we gave that right of action to the Attorney General and to the county attorneys, or in the case of Baltimore City, the city solicitor. We are just, well, the Attorney General has just issued his first case using this legislation and thought it was best that we give this some time to settle with the current scheme of this legislation. As a result, that is why I am asking for this legislation to be withdrawn in this session. Thank you.
Thank you. So the motion is on an unfavorable, and by the way, we're coming back to House Bill 189 after this, so just give us a second. So on the two bills, though, that we mentioned that were mentioned, 1158 and 1205, there's a motion for an unfavorable withdrawn. All in favor, raise your hands. Anybody opposed to them being withdrawn? Nobody. Okay, good. All right, so those two bills are withdrawn. We're back briefly to House Bill 189, and Holly has an answer to the questions that were being asked. This is the bill on the commercial driver's licenses and disqualification for driving. So Holly, tell us what you learned.
Okay, so it is considered a conviction, to Delegate Cardin's question. The MVA advises that under the current law, it's unable to disqualify an individual from driving a commercial motor vehicle via an administrative per se hearing for individuals who register a BAC of .08 or greater in a personal vehicle. But they can do so if the driver drives or attempts to drive a commercial motor vehicle with an alcohol concentration of .04 or greater. They note that the federal regulations require the disqualification actions to be taken upon a conviction, And under the federal regulations, the administrative per se violation is considered to be a conviction. So this legislation is just treating that administrative per se conviction the same as a court conviction. And then it's for purposes of administrative sanctions, it's providing that the CDL holder is going to be prohibited if they're caught with a BAC above a .08 driving any motor vehicle.
So if you lose at the MVA on the .08, you're losing your commercial. Yeah, but it doesn't, to your point about whether there's some kind of due process, there is. They'd have at least the administrative hearing to be able to figure out what happened next.
And just some numbers, they did give me, I have some numbers. So the MVA said in 2023, there were 174 CDL holders that had an offense that would have possibly been subject to disqualification. And in 2022, there were 168. So they were disqualified with a .04 or greater, but they still were able to, or .08, they might have had a .08. They were disqualified, but they weren't able to lose a CDL because it was only .04.
Does that address your question? Yeah. All right, so we're on 189. There's no amendments. Could I have a motion again on the 189? There's a motion for a favorable in a second. All right, any further conversation about the bill? Delegate Schmidt.
Sure. Do they educate CDL while they're going through maybe the licensing process on the ramifications? So somebody gets charged with this, or they lose their CDL, they essentially could lose their job or would lose their job. I just don't know what the ramifications are or the discussion in that process.
The process where they get educated to have a CDL, there's a whole process.
Yeah, like, hey, this is a pretty serious offense. Should this happen, right? I'm not condoning it by any stretch, but I mean, just making sure they know this, you're losing your job. It's
part of, it would end up being part of the law portion of the
test
of getting the CDLs.
Gotcha. Okay.
I don't know if it'd be a question on the test, but it certainly would be something they'd have to learn as part of the process.
Sure.
And it's already federal, so I'm guessing they would already be informed of
There's
it.
different classifications of CDL, correct? Like ABC, I believe?
There used to be, I don't believe there are anymore.
There aren't anymore, it's just one.
I don't think there are.
Okay, all right.
Delegate Cardin.
Thank you.
Thank you, Mr. Chair. When you say it complies with federal law, so there's already a law in the books federally that they have to do this? Or?
That's the Federal Motor Carrier Safety Act. It's just putting this in compliance. So if you're disqualified driving a personal vehicle with a BAC .08, any personal vehicle, you're going to lose your CDL. Because right now, they can only take away the CDL if you have a .04 greater.
One in the truck.
Exactly.
There's a motion for a favorable and a second. See anybody else? Don't see anybody else. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
No.
No. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Congolo? Yes. Erican? Well, might come back. Taylor? Yes. Simpson? Yes. Grammer?
Grammar, you're outside.
Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. Erican? Yes. Thank you. All right. Those are the bills that we have today.
Did we not do my district mate?
We're not doing 675 today because there are amendments that are coming down for 675. Sorry about that. We had yes. All right, so for the record, on 123, there were people who missed that bill. And Delegate Pasteur missed several bills because she was presenting to the Jewish and Black caucuses. And the explosion you're about to hear to my left is Hunter's head. So I'm just going to let you all know that I saw that Simmons, Congolo, and, Tomlinson, Pasteur, Simmons, and Congolo on House Bill 123 were not here. Ed Williams.
Yes.
Is there a motion? Are all of you asking to be recorded in the green on that bill?
Yes.
All right. Is there objection? Without objection, so ordered. Now, so here's what I'm going to do. I can't do it for every single one individually, but Delegate Pasteur was presenting to those caucuses. She got here halfway through. It is my understanding that you would want to vote yes on the bills that you missed. Is that correct? Is there any objection to recording a yes vote for Delegate Pasteur's bills, or Delegate Pasteur's votes on the bills that she missed? No. Hearing none, so ordered. Thank you very much for that. Very quickly for presenting it on the floor, and everyone should remember to, tell staff not to kill the chair. 123 will go to the vice chair. 189 will be me. Delegate Valentine will do 236. Delegate Cardin, 315. Delegate Crutchfield, 437. Delegate Simpson, 442. Would someone like to take on House Bill 445? Delegate Erican, sure.
Okay, she got it. Okay, good. How do you like which one is it?
Do you want to present it on the floor? Okay, great. Oh, really, says the majority leader.
Did you get 468? Who supports it?
It's HGO.
Oh, okay.
It's HGO's primary on 468. 591 is Embry. 604 is very much Williams. 756 will be Cardin. 929 is Simpson again. 943 is Tolles. Another jump ball for 1116. Anybody? I don't think there'll be questions, but why not? No, Schmidt asked to do, Schmidt. All right, so we'll let him do it. All right, 2 o'clock, or is it 2 or 3 on Monday? 2. Virtual hearing, 2 o'clock on end-of-life options with HGO. And so we will see everyone there then on 2 o'clock on Monday. Next week, we are working on the schedule. We will be probably voting several times during the week, and we'll make you have a better sense of it after we get out of the weekend. Delegate Phillips, and then we're going to be done.
2 questions, Mr. Chair. First to my subcommittee chair. That hearing that we had on end of life went hours and hours.
Yeah,
We're scheduled for 4.
Public safety is meeting at noon on Tuesday now. You're welcome.
And then do we know, as leadership met about Friday?
We don't know yet. I don't know yet, but please just stay in touch. We hopefully will know more this weekend, and we'll be letting people know about Friday. I just don't know. My suspicion is that we will do a pro forma session on Friday and that we will not be here. I am speculating, maybe wildly, not sure whether that doesn't mean we're here on Saturday next weekend, along with the Saturday before crossover. So just as a heads up, that might happen. I'm not sure yet, though. With that, several subcommittees are meeting, and they need to get underway. So criminal is at 3:30, and civil is
right now.
right now. Thank you all very much.